In the previous lessons, what we did was spend some time talking about the idea of licenses, and we looked at the various different distinctions which you can make between different types of licenses. Focusing on the idea of the bear license, for example, licenses which are coupled with a proprietary interest, as well as licenses which are part of a contractual arrangement. This lesson is going to start talking about the idea of proprietary estoppel, or sometimes known as estoppel licenses. And we are going to basically introduce proprietary estoppel in this lesson before spending a little bit more time unpacking the key components of proprietary estoppel in the next. These are the final lessons of topic number 7, looking at licenses and proprietary estoppel. And really, we're just going to begin by thinking about the idea of an estoppel license. It's an area of law which can be applied to both contractual licenses as well as bear licenses. Sometimes what this essentially requires is the court applying the equitable doctrine of estoppel in order to prevent a licensor from revoking a license in certain circumstances. Now, I will draw your attention back to when we looked at promissory estoppel in the case of contracts, but I'm going to just really reiterate the point here. What promissory estoppel essentially tells us is that if you have a contractual arrangement which has as part of it some kind of promise, and that the other party to your contract acts in a way that requires the existence of that promise. They act on the promise and they act in a circumstance understanding that the promise exists. Then you decide or try to revoke that promise, leading the other party into a situation and circumstance where they are worse off. What the court will do is apply the equitable doctrine of estoppel to prevent you from doing such a thing, to prevent you and to protect the rights of those who have acted on the promise that you have essentially held. Similar things happen when it comes to estoppel licenses. The revocation of a license in certain circumstances can be stopped using the equitable doctrine of estoppel. Estoppel licenses are a type of proprietary estoppel. Proprietary estoppel protects an individual who has performed acts and done certain things with the assumption and upon the reliance that they will receive an interest in the landowner's land, or even they will receive a fee simple. So you can sort of see the clear comparisons that you can make between promissory estoppel on the one hand, if we then look at the idea of the law of contracts, and proprietary estoppel on the other. The real main difference is not really the nature of the relationship or the nature of the acts that have taken place, but more so the kind of things that are involved in proprietary estoppel versus promissory estoppel. Proprietary estoppel concerns, obviously, interests in land and even in some circumstances, the acquisition of a fee simple. If the landowner in this circumstance where you have an assumption and then that assumption is then revoked, then if they renege on their statement and the individual has acted in a way which relies on the performance of that statement, then estoppel may be revoked. Or invoked, should I say. Now, just like with promissory estoppel and just like with any equitable doctrine, you also have to rely on things such as the equitable maxim that equity acts as a shield and not a sword. So essentially what this tells us is that it can only be used, estoppel can only be used as a defense. This is the exact same situation as is in the case of promissory estoppel. Lord Scott will define proprietary estoppel in the following case, the case of Coombe and Yeomans Rao Management Limited from 2008. They say that, quote, an estoppel bars the object of it from asserting some fact or facts, or sometimes something that is a mixture of fact and law that stands in the way of some right claimed by the person entitled to the benefit of estoppel. The estoppel becomes proprietary estoppel, a subspecies of promissory estoppel, if the right claimed is a proprietary right, usually a right to or over land, but in principle equally available in relation to chattels or choices in action. So essentially what this is suggesting here is that you should really understand proprietary estoppel as just a subspecies of the broader promissory estoppel. The only real difference here is not to do with the nature of the arrangement, the nature of the acts that are committed or done, like the promise being revoked, for example, but the only real thing that is different between proprietary estoppel and promissory estoppel is that in the former, the right that is being claimed is a proprietary right. It is a right over some land, or a right in some land, or to some land, whatever that may be. And so if we remember back to promissory estoppel, essentially what promissory estoppel does is it prevents a person from reneging on a promise for which the other has relied upon. And so the result here is that what we are doing here is we are preventing people from reneging on a promise for which the other person has relied upon in relation to a proprietary interest, an interest in or over a piece of land.